Someone make it make sense.
Probably a couple.
Y'all, I accidentally clicked on the outro for a second there. You know why? Because we are professionals. Just like that, guys. Just like that. We are professionals. That is really funny. Every now and again, I click the wrong thing. You know, it happens. It happens. How's everybody doing? Here's a 5-hole just to start off on the right foot here. Y'all. Hi, Candace. Welcome. Happy to see you as always. Yeah, this is a crazy one. By this, I mean Judge Bev. Judge Bev, who has decided to just basically broadcast how she really feels without even pretending anymore. We're going to stop pretending. That's what's happening there. Yeah. So I do have a fun little treat here. What I'm going to do is I'm going to read this and then we'll go to the little treat and then we'll come right back. Because look at this. This is just so short, right? And sweet. It's just not sweet, but short. It's short only. How about that? So this just got, I think, fucking yesterday, maybe the day before. Time is a construct. Just recently posted here. All right. Decision and order on defendant's motion to exclude the testimony of the Commonwealth's witness, James Crosby, MS, PhD. After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. Footnote 1, we already know what that is. I hate Judge Bev. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There's an appropriate basis for his opinion in the record. And the proposed testimony, principles, and methods employed are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. How many sentences is this? How many sentences is this? One. Wait, that's one sentence. 2, 3 sentences. Now, this is not a sentence. This last one, that's the cite. That's the citation. And the way you have to do citations is it has to be like that's correct. Like the way that there's a period there. Like in other words, while this might look like a sentence, it's not a sentence, it's a citation. So what did I say? 1, 2, 3 sentences. 3 sentences, people. 3. We're going to come back to it, but let's real quick just take a look and compare it to Dr. Russell, who was allowed, right? Granted. Well, the Commonwealth's motion was denied, in other words, right? And how much longer? Like, let's just take a look. I mean, now we covered this already, but just to compare it, we covered this, like more than 3 sentences, I shall say. Okay. So now, as promised, we're going to take a little hot minute. It's like quickly here. I have a little fun treat. We're going to just take a break from Judge Bev real quick and have a little dance party. Okay. So this just randomly popped up on YouTube. There we go. Like on the home thing. And like literally, and sorry, you're looking at some dude's butt right there, but like this just popped up. I'm like, okay. And like literally the title was enough for me. Guy starts dance party. Done. Click. Okay. I don't know anything about it apart from Sasquatch Music Festival 2009. But this video is amazing. Okay. So shout out to 2009. Shout out to this dude. So let's just watch this because this is amazing. I think you guys will love it. And this is our break from the bias that we are going to be encountering here. So here we go. Shout out to that dude. love this. What's amazing is all the people, there's people just like staring at them. I love this so much. The thing is, you can only resist the good vibes for so long, right? Yes, number 3. Here we go. Okay, we got some more people. Yep. Now we got. There's people cheering. They were just like rooting for him, but they didn't like. This is hilarious. Like there's people rooting for him, even though they didn't want to go over and join the dance party themselves. You've got actually this dude down here who's laying down in the red shirt and the green hat. He's filming it. This is amazing. Like film the way that people are watching but not participating. I don't know. I think this is hilarious. I totally would have been the first person to go over there and fucking join. If not the original, like, yes, I'm all about a dance party. Yay! I love this so much. I love this so much. Wow. What's funny is these onlookers are about to get fucking trampled if they don't get up and start dancing. Amazing.
I got to be unstoppable.
Oh my God, amazing.
I got to be unstoppable. That's right. I believe you got it.
Look at the mountains. I'll have to look Sasquatch. I wonder where this is at. Right? Totally life affirming. Now, what's the thing is that's interesting is like at a music festival, normally everybody's dancing. So it's weird that they weren't dancing. But what I will say is this is an interesting, like from a psychological perspective, this is fascinating, right? Because like in like less than 3 minutes, like what's interesting is if you look at the whole thing, it's the one dude by himself for like what? The first 20 seconds. Then you have dude number 2 joins. You don't get to the third dude until, wow. You don't get to the third dude until like a minute in. And then in less than, I mean, Jesus, in like a minute and a half after that, you've got everybody pretty much, right? Which is pretty crazy. And so it's interesting, right? The psychology of it, of that. It's like when people don't want to be the person who's not doing the thing. So it's like initially no one was dancing. So when the one dude started, it's like people were hesitant to like join him, right? But then when everybody does it, then it's okay. So while I freaking love everything about dance party, my point is kind of like that. Why are people waiting for everyone else to join in, right? Why not be that dude number 2? Why not be dude number 1, right? Why not be dude number 1? Okay, so wow. So this is in Washington State, it looks like. Sasquatch Music Festival. It does not return. Unfortunately, it's not happening anymore. It stopped in 2018. But it was in... That's funny. It was in George, as in, I guess, George is a city. Washington State, looks like. So, Twiz, you could have gone if you're listening. So there it is. There you go, guys. Okay, so now back to the depressing documents. All right. There you have that. By the way, StreamYard has changed how it does. I don't know. StreamYard's messing around with things. So I don't know why, like, it just doesn't show anything if I move, if we switch up what's being shown to you guys. But anyway, okay. So yeah. So again, so we had our 3 sentences here, denying Dr. Crosby. Okay. And then looking at the difference here with Dr. Russell, right? Like, much more thorough, right? Again, we already covered this, but before a witness can provide expert testimony, the court is the gatekeeper, right? And like the best part, when I say best, I mean the worst part is like when she says, although a close call, which I think is on. The second page, where is it? There's that one part where she's like, although a close call, there it is in the first paragraph, at the last sentence of the first paragraph. Although a close question, the court will deny the Commonwealth's motion. Like, that wasn't necessary, obviously. And then there's like the part where she's like talking about how they did great on cross. Oh my God, I just can't. Anyway, but like in other words, the length here is only just to try to essentially indicate how she really feels, right? Because the extra judicial, no, sorry, that was automatic. The extra little snidey ass statements aren't necessary for the record in order for her to make her opinion here in order. Like, it's not necessary. And then you look at this, which, yeah, it could have been fleshed out a little bit more, Judge Bev, but like, also what the fuck, right? Like, also what the fuck, how? This to me reads like someone who didn't listen at all to anything that happened on March 4th in the hearing, and who just completely doesn't care. This is like someone who doesn't care and isn't even trying to look like they care. This is like literally you copied and pasted like a sample, order allowing an expert witness. And whenever it said expert in fill in the blank, you put dog bite wounds. And the rest of this is just boilerplate, like literally rubber stamp. I mean, it's crazy. How are you able to say he's an expert in dog bite wounds? I mean, I just don't. Now, no, again, the other thing, right? It's like there's nothing to support any of this. Like, she's saying he's an expert in dog bite wounds. How? There's nothing to support it. And then when you get to Dr. Russell, there's all this, I mean, I guess on the bright side, there at least is something to support her findings here, at least. I mean, when you think it can't get worse, right? Okay, so now, are these out of order? So annoying. Okay, I think these are somewhat out of order. Okay, that's okay. So here's the first page. So now we're going to go to this supplemental motion for admission. So on March 5th of that hearing, right, whenever that was, a couple days ago, I was actually asking y'all, I was like, dude, where's Mark Bederow? Why haven't we seen him already, right? Because it was like, I know that they had to do a supplemental, they had to supplement their motion. By they, I mean the defense. But I assumed that this had already been buttoned up already, and that because, it's so unusual for people to not get approved for pro hoc vice, right? It was sort of like a given. So I just figured that had happened and we had missed it because we were in the middle of these crazy ass hearings. And when I was asking the question, in fact, people in the chat shout to those people were like, he's actually right now, he's like with Turtle Boy, like in court. And so that's probably why he's not there. And I was like, oh, that makes sense. Right. And it's like, okay, so I guess he's just going to be there for trial. Like, I don't know, like, the next hearing is not until the 18th. So anyway, but this just got posted again. I think it was like yesterday. So this is the, actually, yeah, I think it even says March 7th on here for the date. So supplemental motion for admission, pro hoc vice of Mark Bederow. So, so David Yanetti is right here on the following grounds. 1, at this court's directive, this affirmation is intended to supplement my pending motion for admission pro hoc vice of Mark A. Bederow, so that Mr. Bederow may represent Karen Reed at her upcoming trial before this court. I incorporate by reference all the contents of my previous affirmation in support of that motion. 2, the source of the information contained herein describing Mr. Bederow's qualifications and background comes from my conversations with him and information he has provided to me. If the court requires any additional information not contained in this affirmation, Mr. Bederow is available to speak to the court ex parte about any issues relevant to the motion. Now, remember, some of the things that were raised from the freaking Commonwealth was like, oh my God, it's so crazy. It was like stuff that there was nothing to support it, right? There was nothing to support it, but it was like this concern that maybe there would be information shared between the different parties and that Turtle Boy is all up in this case and vice versa. And like that they could be co-defendants. It was basically nonsensical in my view, what the Commonwealth was saying. And I was like, this is a fucking joke. It was clear to me that for obvious reasons, they just didn't want Mark Bederow on the team because he's a good attorney. And it was sad and pathetic, in my opinion. But Judge Bev seemed to be persuaded enough to require this additional supplement to their motion. Number 3, Mr. Bederow has been a member in good standing of the New York Bar Side Bar since 1999. He is also admitted to practice in the state of New Jersey, Southern District, yada. Okay. He's presently admitted pro vice in Massachusetts on 3 criminal matters, 2 of which are pending in the Norfolk Superior Court. Now that matters, right? Because again, it's so unusual for people to get denied anyway for this, but he's already been approved in the state. So it's like, this is a no-brainer, right? This is a no-brainer. Should be. The other matter is pending in the Dedham District Court. In 2009 through 2010, Mr. Bederow was admitted pro vice in the District of Connecticut in connection with a complex federal criminal matter. In more than 26 years of practice, he's never been sanctioned or disciplined by any court in any jurisdiction in which he has been admitted to practice. Number 4, good cause exists to grant this motion because Mr. Bederow has specialized skill and knowledge in representing criminal defendants in matters of this nature. Since 1998, Mr. Bederow has been engaged in the practice of criminal law. From 1998 to 2004, he served as an assistant district attorney in the Manhattan DA's office, which is one of the largest and most prestigious prosecutor's offices in the U.S. From 2004 to 2008, he practiced criminal law at a large national firm. Since 2008, he has had his own criminal defense firm in Manhattan. During his career, Mr. Bederow has been involved in many complex homicide cases and other serious cases, including some with issues similar to those in Miss Reed's case. Miss Reed values Mr. Bederow's experience and legal skills and desires that he be allowed to represent her at trial in this matter. I will say, he's great. Love Bederow. I don't know why they need another defense attorney unless they maybe were thinking that Jackson was going to get kicked off the case. Because it's like, I don't know. I just don't know why they would need another attorney, but that's not grounds to not admit somebody, right? If they ask for it, that's not a reason to not allow them to be admitted pro vice. That is up to the defense team. And if they deem it appropriate, if the defendant wants more counsel, she can have more counsel, right? Okay, number 5, as the court is aware, Mr. Bederow presently represents Aidan Carney on 3 criminal cases in Massachusetts. One of those cases involves several witnesses who are scheduled to testify against Miss Reed. 6, prior to the filing of the instant motion, Mr. Bederow conducted separate and extensive discussions with both Miss Reed and Mr. Carney. He defined and explained actual and possible conflicts of interest and the concept of waivable conflicts. He explained to Miss Reed and Mr. Carney the possible conflicts that could arise in his representation of both in separate matters that involved some of the same witnesses. He answered any questions either client asked. He reviewed rules 1.7 and 1.8 of the Massachusetts Rules of Professional Conduct with Miss Reed and Mr. Carney, and then presented both with copies of those rules. Mr. Bederow instructed both clients to speak separately with other existing counsel about these issues. Both clients discussed these issues with their own counsel outside of Mr. Bederow's presence. Number 7, after both clients expressed an interest in his representation after they consulted with their own counsel, Mr. Bederow prepared a detailed written explanation of possible conflicts of interest that could happen and what could happen in the event of an actual conflict of interest. Both clients, with the advice of their own counsel, acknowledged that they understood these issues, confirmed that they wanted Mr. Bederow to represent them, and executed written waivers to any possible conflicts of interest related to Mr. Bederow's representation of Miss Reed and Mr. Carney. Also, in case I didn't say it, shout out to Franks. Glad to see you again, my friend, as well. I think you might have joined us. We were in the middle of having our little dance party. All right, number 8, both Mr. Bederow and I unequivocally confirm that there is and never has been a, quote, joint defense, end quote, privilege between Miss Reed and Mr. Carney. Yeah, of course there hasn't. Mr. Bederow has not shared any protected material provided to him as part of his representation of Mr. Carney with Ms. Reed, her counsel, or anyone else. Mr. Bederow has never engaged in any conduct during his representation of Mr. Carney, or anyone else for that matter, for the purpose of harassing or intimidating witnesses against Ms. Reed and or Mr. Carney. Mr. Bederow will not share any protected material provided to him on Ms. Reed's case with Mr. Carney or vice versa. And then number 9, Mr. Bederow had no role in the preparation of a recent motion filed with this court, which led the Commonwealth to seek sanctions over an alleged violation of a protective order due to the inclusion of a text message sent by Michael Proctor. Mr. Bederow was not provided any protected material by Ms. Reed, her counsel, or anyone else in connection with that motion. Shortly after that motion was filed, Mr. Carney's attorneys filed a motion to dismiss the indictments against him. That motion included references to some text messages and electronic communications that were subject to a protective order in that case. The publicly filed version of that motion, which is available for this court's review, includes redactions of any messages that are subject to the protective order in Mr. Carney's case. In one footnote, there is a reference to a series of many inappropriate statements made by Michael Proctor, all of which were in public record before Mr. Carney's motion was filed. And then number 10, on February 18th, 2025, the Commonwealth stated that it did not object to Mr. Bederow's admission per hoc vice to the defense, providing additional information to this court ex parte before the court decided the motion. Wherefore, for good cause shown, Mr. Yanetti respectfully requests that this motion be granted. So they did as she requested. All right, ready? This is crazy. You just never. Okay. Decision and order on defendant supplemental motion for admission per hoc vice, Mark Bederow. After review of the pleadings, the defendant's supplemental motion for admission per hoc vice of attorney Mark Bederow is denied. Look at this. This is disgusting, and I'm going to smash something. In scare quotes, affirmation. You guys. The affirmation in scare quotes. I'm sorry, it's just not necessary. Dude, I would not be able to practice in front. I just couldn't handle this. This is so disgusting to me. The attitude. This is why the thumbnail and it's like, it was clear to me once we got to scheduling at that hearing on March 5th, it was clear to me. I was like, oh, she's not even pretending anymore. She's not pretending. She doesn't care. She's not even making any attempt to pretend to not be as biased as fuck. Not even, just gives no fucks about it, right? Both this and the Dr. Crosby one, same. Like, this is like broadcasting. I'm biased. I don't even care anymore. I just want this trial to be over with, and I don't care about people's rights. That's what this is. Yeah, the part that I'm saying is disgusting is the affirmation in scare quotes. There's no need for that. That's just to be a bitch, basically. That's just to be like, it was an affirmation. She asked for an affirmation, right? He submitted an affirmation as per her request, which happened after they met ex parte. To put it in scare quotes like that is just simply there's no need for it unless it's to try to show them that you don't think it was good enough. Like, you guys see what I mean? Like, it's condescending. It's condescending as fuck. That's as far as I've gotten on this right now. So the affirmation in scare quotes submitted in support of the motion is insufficient on its face. In addition, the proposed concurrent representation involves a conflict of interest that is not waivable under Massachusetts rules of professional conduct. See also comments 22 and 23. One such conflict is specifically outlined in the motion at paragraph 8, where Mr. Bederow, apparently speaking through Mr. Yanetti, promises to restrict his use of certain information. What? She says number 8. She says Mr. Bederow speaking through Mr. Yanetti, as if Mr. Bederow wrote it. This says both Bederow and I can unequivocally confirm. What? Like, in order for that to be the case, it would have to be written like in the first person, right? When it comes to Mr. Bederow, like Mr. Bederow speaking through Mr. Yanetti. What? I'm just going to read this. Okay. Both Mr. Bederow and I can unequivocally confirm that there is and never has been a joint defense privilege between Miss Reed and Mr. Carney. Mr. Bederow has not shared any protected material to him as part of his representation of Mr. Carney with Miss Reed, her counsel, or anyone else. Mr. Bederow has never engaged in any conduct during his representation of Mr. Carney or anyone else for that matter for the purpose of harassing or intimidating witnesses against Miss Reed or Mr. Carney. Mr. Bederow will not share any protected material provided to him on Miss Reed's case with Mr. Carney or vice versa. Help, guys. How the hell do you get, like, what? One such conflict is specifically outlined in the motion at paragraph 8, where Mr. Bederow, apparently speaking through Mr. Yanetti, promises to restrict his use of certain information. What? The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation of the other client. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro vice. So, well, like I already said, I don't know why they need another attorney, but that's not up to me. That's their choice, right? So this, though, is interesting because it's very reminiscent of what happened with, let me be clear. If what Judge Bev was saying was accurate, it could be reminiscent of like what happened with Charlie Adelson, right? And Dan Rashbaum. You cannot compare the two. You just can't even compare the two because they're too different. You can't even, the only reason I even say that is because of this part right here where it says, where it references like information known to the representation of one client where the information would benefit the second client. Here's what I do know. I don't think he would, to the extent that any of that is true. Anybody who thinks that Judge Bev is looking out for Karen Reed by denying this is, I don't even know. Like, does Judge Bev, I mean, like, I can't even say it because it seems so insane to say, like, that it would need to even be said. Like, if Judge Bev had Karen Reed's best interest or constitutional rights, even remotely, even if she cared, even a modicum, things in this case would be vastly different. That's why this is like, oh God, it's so hypocritical. It's so hypocritical. And it's so many things. I don't even know where to begin. It's like it's like making this ruling under the guise of looking out for, and if not Karen Reed, then it's Turtle Boy, right? Which one of those does she care about, right? Jesus Christ. Do you think she cares about Turtle Boy's rights? Do you think she cares about Karen Reed's rights? Because if so, what else could support that being the case? It's disgusting. It's like, when she has the opportunity to do anything that actually puts Karen Reed's rights or actually values them or does, okay, let me back up. When she has the opportunity to not participate in trampling Karen Reed's rights, let's go with that. When she has the opportunity to not trample those rights, she doesn't take that opportunity, right? However, when faced with a decision where she wants to make this choice up for here with Mr. Bederow, right? Then she gives the reasons being it's basic, like essentially what this is saying, right? Like what she's trying to say is she's looking out for Karen Reed, right? Or Turtle Boy, or both. I mean, I don't even know which one is more ridiculous. Oh God. Oh my God. Oh my God. Oh my God. Right. It's not up to Bev how many lawyers. Right. Of course. She's 100% biased. It's clear. And for you guys who missed it, like, y'all, when we watched the March 5th hearing, we watched the whole thing. And then we got to the scheduling, which if you're anybody who was only seeing the court TV feed, you missed the most important part of the entire fucking hearing. And it wasn't very long. It was like the feed cut out for like 3 minutes or something. And so much happened in that 3 minutes. Okay. So we watched the whole thing and we went into another feed and we got that part. And like literally we went back and watched the entire hearing again, pretty much, because I was like, oh, okay, this completely changes how I understand all of this. The scheduling was the most important part of the entire thing. I had a lot of thoughts, and I think I've finished. Yeah, I have finished the timestamps as well, by the way, on that one. So that was where I started to see, oh, okay, all right, yep, I see what's happening here. Wow. And so that's where it was clear that she's not even pretending anymore to the extent that she was able to at all prior. Right. Yeah. I suppose if you're strictly reading the words on the page without any context, I suppose you could take that. That's the guys. Like it's like a misappropriation of people's rights, right? It's a misappropriation of Karen Reed's rights to try to support what she wants to happen. But whenever she doesn't want something to happen, it's like she just picks and chooses, right? When rights are important. I mean, the thing is, right, is if you compare it again to like Charlie Adelson, I don't think everybody in that situation was like, yeah, obviously this is a problem because, Dan Rashbaum is representing Charlie and Donna at the same time, and they're co-conspirators in the same criminal case. And this is a family that's already like as toxic as fuck. And Dan Rashbaum was already in way too deep and all this, right? There was like a lot of issues. And the fact that like Donna and Harvey weren't called to testify at the trial. And then you had the weird ass strategy, the triple extortion theory, and it's like, it was one of those things where it's like, it seemed like a bad idea from the get-go, right? But then everybody kind of thought, well, surely that, somehow they must have waived it and decided it was okay. Like, I don't know how, but like that must have happened, right? Come to find out, it had not happened. And that's the other thing. That is the other thing that we have to mention, is that the reason it all went to hell in a handbasket, as they say, is because Charlie never did end up signing that waiver. Dan Rashbaum represented to the court that he had, or that he thought he had, when in fact he hadn't. Okay? So right off the bat, you have a difference here where Karen Reed and Turtle Boy, I'm just going to find it here. Not to mention, guys, that the Commonwealth stated it did not object, right? Look at number 10. The Commonwealth did not object. Right. So it looks like oh, are these out of order again? 6. Yes. Here we go. Okay. Both clients discussed, after both clients expressed interest in his representation after they consulted with their own counsel, He prepared a detailed written explanation of possible conflicts. Both clients, here we go. Both clients, with the advice of their own counsel, acknowledged that they understood the issues, confirmed they wanted him to represent them, and executed written waivers. There it is. Again, so this is a difference, even though the conflict was obviously so much worse when it comes to Charlie Adelson and Donna Adelson. Here, they have written waivers, right? Both Karen and Turtle Boy signed their written waivers to any possible conflicts of interest. Again, just to reiterate, that did not even exist when it came to Donna and Charlie, right? And yet for months and months and months, Dan Rashbaum represented Donna, even though that seems like a clear issue. Even that didn't cause concern for Judge Everett, okay? Until it became known that it was discovered the day before trial that there was not a waiver signed. So that's a good example. I know a lot of you guys are familiar with that case where you can compare it to that, and how I'm just shocked. I mean, when you've got an attorney who's in good standing and has never been denied admission to Rock Vice, who has never been sanctioned, you've got the clients who have signed their waivers, right? In other words, there is nothing to support what she's saying that we know of. There's nothing to support it. And honestly, when it comes to representation, when the due diligence has been done, in other words, you've got an attorney who is in good standing with the bar, especially he's already been admitted in that state, but then they went and they met with the different clients. The clients signed the written waivers after meeting with their own respective counsel. This is like Judge Bev trying to say to Turtle Boy and Karen, you know what? I know what's best for you. You don't know what's best for you. Your attorneys don't know what's best for you, but I know what's best for you. That's what this is like. Right? It'd be different if they didn't sign a waiver. We wouldn't be here if they didn't sign the waiver. Twiz is here. I love double extortions. Love it. Yeah, no, I agree. Yeah, it is crazy. It's crazy. It's crazy. For anyone who missed it at the beginning of the live stream, we had a fun little dance party moment. So if, you might want to go back after this and, maybe we should just do it again. Maybe we should just do it again because this is just so much. I should have saved it. Maybe I should have saved it. Damn it. Because it's a lot. This is a lot for me. Like Judge Bev knows better. Judge Bev knows better. Like pat on the head condescendingly, right? Like to you, Turtle Boy, to you, Karen Reed, to all of your attorneys, you don't know better. I know better. Like, dude, no. This is disgusting to me. I'll tell you what else. I think that a lot of this is me. This is me. If I give her the benefit of the doubt, what I can say is this, that a lot of these recent decisions are out of her desire to just go to trial on April 1st. That above all else, no matter what happens, people could die, the courthouse could blow up. She's going to trial on April 1st, even if she's there all by her fucking self. Again, you look at this, where is it? Here. You look at this, right? It's like she doesn't care. Like, this is the best case scenario, right? This is me giving her the benefit of the doubt. Is like, the benefit of the doubt here would be that she just, not that I'm saying this is the right thing or what should be happening. This is the best case scenario, in my opinion, is that she's just has to get to trial on April 1st at all costs, right? Nothing's going to stop her from going to trial on April 1st. So like we get these short rulings, there's nothing to support it, but also, had she said, okay, I'm going to hear voir dire on Mr. Crosby, I'm sure the same thing's going to follow with the other expert witnesses too, right? Had she said, okay, we're going to hear voir dire, when? They have a hearing on March 18th, and I think on the 19th, and that is for motions in limine, and that's it. That's why that scheduling shocked me at the end of the last hearing, because when you hear them go through that scheduling, I mean, it is, in other words, all of the pending motions, she basically just flat out admitted they're all just going to be denied because she's already got her schedule set for the 18th and the 19th. They're going to hear the motions in limine, and then whatever it was that Mr. Alessi was going to argue on the 5th and didn't have time, that. She asked him if he could do it in 10 minutes. He's like, no. And that's it. So in other words, what does that mean? Well, we haven't even gotten to motions in limine in terms of the pleadings, right? So all these other pleadings that are on the table for this thing to be heard, or voir dire of this, or reconsideration of that, it's all going to be denied because they're not. She's like, I'll see you on the 18th. And then on the 19th. And then trial starts. Gotta be fucking kidding me. Like, what is happening? Bye, Candace. Thanks for being here. So, and hello, Meg. Welcome. So I just, so both this one, right? And then the next one, they're just fucking short. And again, like, I wonder if part of it, this is me giving her the benefit of the doubt. If part of it is like, if she admits a new attorney, if she thinks that maybe they can ask for a continuance, right? Because now they have a new attorney on the case. That would be, that could be part of her decision. Now, she doesn't say that. Again, this is me giving her the benefit of the doubt. She doesn't say that, but that could be part of her decision, is that, well, if I allow him on, they might say, well, now we've got another attorney, so we need an extension, right? Could continue the trial date. And I wonder if that's a big part of it. And like, again, her motivation above all else, at any cost, going to trial on April 1st, no matter what else. So anything that is requested that will require any other hearings, like another hearing, or could possibly cause any type of delay, is going to be just denied. And for that reason, as I articulated when we were watching the March 5th hearing, I fully expect her. She's going to deny that whole thing. She's going to deny the evidentiary hearing, and she's going to deny the entire motion. Mark my words on that. She made that clear when they got to scheduling. It was disgusting. She didn't even pretend. She didn't even say, she didn't even do what Judge Hippler did, right? Remember Judge Hippler for Franks was like, okay, can you just email me some days that you're available in the next 3 weeks? And it's like, you know what? The reason that is better than what happened with Judge Bev is this, because if you're not going to rule from the bench, right, then you need to at least act like you're considering it, right? That's the difference. Whether he was actually considering it or was just pretending, either way, he didn't rule from the bench. And so to say, okay, give me some days you're available just in case for the Franks hearing, makes sense. Otherwise, rule from the bench, right? So at the end of the hearing on the 5th, right, Judge Bev says, yep, here's what we got. We're not going to add anything else. We're going to wrap it all up neat with a bow. She doesn't even pretend to say, okay, what if we need to have an evidentiary hearing? Why? She have to push the trial date out. She doesn't even pretend. She doesn't even entertain the thought. She doesn't even pretend to entertain the thought. And yet she doesn't roll from the bench. So it's hard for me. Yeah, there's no way that would happen. It's a good question. Need some pieces asking. I'll just go ahead and read it. Question, that lawyer that was a juror in the first trial, I think they were an alternate. Could they represent Karen in this trial, given she had experience? Right. Even if you didn't have Judge Bev, there's no way. I don't think that would happen no matter what. Yeah, that would be a conflict for sure. It is unusual though. I don't think there's anything specifically in the ABA model rules that say a former juror representing. I mean, because that's just it's interesting. I don't think there's anything specifically that deals with that, but I can guarantee you that wouldn't fly. I don't think in any court, not even just Judge Bev. Welcome, Kane. Welcome. I don't know. It's I think it's time to go back and just one more time for the road here, our little dance party. Because this was so much fun and I can't with Judge Bev. So here we go. Again, we looked it up earlier. This is from Washington State, apparently. Doesn't exist anymore, but used to exist. Sasquatch Music Festival, 2009. We got some good vibes to end this disaster with. And we're going to have another live stream, by the way, guys. I've got to go teach some lessons, and then I'm going to come back and we're going to do BK. But first we're going to have this moment. I love this so much. It would be me. It would have been me if I'd done this. Raise your scroll call if you're dancing. Yes, he's number 3. Let's hear it for dude number 3. I love that. Okay, hold on. So this came up on YouTube on my home screen earlier, and I was like, this is amazing. I don't know how it came up. It was just one of those random things, but I clicked on it because it says Guy Starts Dance Party. Done. We're watching it, right? So this is from the Sasquatch Music Festival in 2009, and we watched it earlier, and I wanted to watch it again because I love this. This makes me happy. This takes me out of hatred towards Judge Bev, and into dance party mode. And like, it's just the good vibes that are contagious, right? I just love this so much. And shout out, we're just gonna watch this again. Like, I love this. I just love this. It's short, but it's like, you can see how quickly the good vibes are contagious here. Is a good year. I would have just been entering my senior year. Yeah, love it. Love it. Look at all these people. So there you go. So that's that. Anyway, I love it. I love the good vibes. So tonight, guys, we're going to be doing more on BK. Right. Yes. So I realized somehow I didn't actually finish the entire document with the text messages and the the one that's the text messages and testimony of BK and DM, it looked like it was the end, but like it wasn't. Anyway, like I knew, okay, somehow I missed like the last 2 pages or something like that because we went back to the 911 call transcript, and then I guess I thought I'd finished it, and I didn't realize this until I was doing the timestamps, basically. So essentially, we're gonna read the last couple pages of that tonight, and I have some more thoughts on it anyway. And then we're gonna do the Amazon click activity, the touch DNA, the conditions as aggravators, and the motion to strike the death penalty for autism spectrum disorder. That's the plan. And I believe I already have a live stream slated for tomorrow for part 4. Anyway, but yeah. So, but I'm going to go teach a couple lessons, and then I will be back and we will cover some of those BK docs. So hope you guys can all join us for that as well. But yeah, that's it that's the latest. That's the latest in Karen Reed, guys. That's literally the latest there. That order denying the admission for Vijay was the most recent court filing to come out for her case. So so you guys can be all up to speed. Again, timestamps are all done for the hearings on the 4th and the 5th. I know you guys have all probably seen them, but if you want to watch them again or for the first time or whatever the case may be, the detailed timestamps will help you guys, especially if there's certain things you want to look for. I would say that in terms of the hearing on the 5th, round 2 is probably where I feel like it's going to be the most important, because everything is different after you get to the scheduling, which happened at the end. It's like after we got to the end, we got scheduling. I was like, well, now we got to go back and watch the whole fucking thing again, because now everything's going to mean something different than what it seemed like because of the context. So we literally, and actually DSN joined at hour 7, and he's like, what are you guys doing here since last night? And I was like, yep, we got to the scheduling. And then I was like, we got to go back and watch it again. Also, we did also read the entire, or almost the entire, Gretchen Voss article, which, by the way, both attorneys, as in Hank Brennan and Alan Jackson, misquoted when they talked about that. That came up a number of times with like the pieces of taillight versus piece of taillight. Turns out they both were misquoting it. But anyway, we read that article, and I also linked the article in the Discord. So there's some interesting things that we kind of went through. So feel free to check that out. But anywho, don't want to turn the lives down if we don't want you to teach too. Well, here's the thing. I'm totally fine with that. But the problem is for my students, though, that's not really fair to them. You know what I mean? I would totally be fine with like myself teaching, right? For you guys to see what that looks like. But for my kids, though, I don't, that's not cool. That's not cool. They don't even know. So yeah, I'm trying to think if there's a way. Well, not with my kids. So don't know. Yeah. I'm just thinking if there was anybody that played violin in the Squirrel crew, right? And they wanted to do like a lesson as part of and they volunteered to do it as part of like a members only stream or something like that, so that they could A, have a free lesson, and B, people could see what the heck it looks like. Like I be totally open and down with that. But I don't think there is anybody that plays violin or currently has violin and plays violin in the Squirrel crew. But I mean, we got Kit Smits who plays piano. I know we've got some guitarists. So anyway, and also, who knows if anyone else cares, Twiz? It might just, I don't know that if people are interested, right? But I have no problem. Like I was going to say, like, it's hard to do like teaching if you don't have a student. Like it would be hard for me to be like, here's what it's like teaching, but then there's like not any other person, anyway. So I would need somebody to have that would be willing to play and do a lesson, I'll keep it in mind, though. And if anybody listening here plays violin and is like, I want to do it, then you can be our volunteer if you want to. So, but anyway, I will be back at 11:30 maybe sooner, depending on how my kids do with finding all their stuff, like their pencils and their music. But anyway, we'll be back for that. So, but in the meantime, y'all are the best. Love you guys. And I'll see y'all soon.